continue its argument.
Thank you. May it please the court, the appellee cross appellant also appears by Stephen J. Obermeyer this morning. I am prepared to argue the claims that my colleague argued, claims 49 and 50, the aggravating factor jury instruction 7, aggravating jury or penalty phase instruction 12. I also am prepared to argue search and seizure issues, admission of uncharged attempted homicides, and any other claims I think that weren't addressed earlier. So,
how about the way the charges were configured here?
okay.
I'd like to talk about that for a little bit. This is my first question. If the murders of the four women, Stasi in the Face and Bonner, were part of a common scheme or course of conduct with the murder of Suzette Troughton, and they were part of a common scheme or course of conduct with the murder of Isabel Lewicki, then aren't they also necessarily part of the common scheme or course of conduct with each other? And I just am curious why it got charged the way that it did, as opposed to just charging the Troughton and Lewicki murders together as one capital count. You know, if you can just explain all
Yes,
this, that'd be great.
I think the answer, it was discussed at the ruling on the bind over on March 2nd of 2001,
Okay.
where Judge Anderson had asked at the conclusion of the preliminary hearing, why aren't the Suzette Troughton count and the Isabel Lewicki count in the same count of capital murder? And there was argument before the bind over ruling, and the state explained, as I understand, given the law in existence back then, that to include one with another may impact the ability to proceed to the penalty phase. There was some discussion as to that, but that's where the discussion is as to why they were in separate counts, counts 2 and 3, where you do have the same course of conduct victims, but separate.
I'm not getting
counts.
that when you say that is why. I don't understand the why. That it may impact the penalty phase. Can you explain how it would impact the penalty phase any more than the way it was charged? I mean, you're asking for the death penalty, so it
Right.
doesn't seem logical to need 2 counts of the death penalty.
Right.
And I just don't understand when you have a very easy to understand, simple way to charge 2 post-enactment murders as capital murder, you would forego that for creative charging. You had to go through some creative thinking to come up with the pre-enactment deaths as being part of the course of conduct. Obviously, because you struggle real hard in your brief to explain continuing offense and implied retrospective and all that. And so I don't understand how you gain something by foregoing simplicity and facial validity for facial invalidity, potentially. You understand what I'm asking you?
I understand, Justice Johnson, and my best answer is if you look at the transcript of that hearing, the state explained why it did not include those 2 victims in the same count, and it had something to do with the penalty phase, is my recollection as far as how that would work.
Given the way it was charged.
If they had
They could-
included them
and
both in the same count.
Right, and it was conjunctive. I mean, in other words, the state took on the burden of demonstrating all 5 murders for each capital count.
Correct.
And then it, of course, had its separate charge of first degree for Ms. Stasi. So, as we sit here today, why is Mr. Robinson not convicted twice for the 4 predicates included in each capital count and 3 times for Ms. Stasi?
The two of the victims were not included in each other's counts or jury
Right,
instructions.
Right, that's why I said 5 rather than 6.
Okay.
There are 4 predicates in each capital count, and they're the same, correct?
Okay, right.
Yeah, so those 4, or excuse me, for 3 of those 4, it seems that he has 2 convictions.
Right.
And for one of them, he has 3.
Right.
Is that right?
That is right. And
Okay. And is that okay?
well, if I argued that this is, as far as multiplicity, this is different because you have different victims in each count. But if the unit of prosecution is the same course of conduct victims in both counts, and you can only count that toward one of the victims, either Isabella LaVisca or Suzette Troughton, then would that not make count 3, for example, premeditated first-degree murder? Because you have intentional killing of one person with premeditation. We're not going to count the common scheme because you already counted that in count 2. So that's why I think it's a little bit different as a multiplicity issue from your other multiplicity cases where those other counts were dismissed. We don't have it. Suzette Troughton mentioned in Isabella LaVisca's count and vice versa.
Should we assume that Ms. Troughton and Ms. Lewicka were part of that same common course of conduct grouping that you just discussed? Should we and can we assume that?
We didn't.
They weren't charged as part
right.
of
They
the,
weren't.
and-
They
and
weren't charged that way.
There was
so-
no jury verdict that they were part of the same
Right.
course of conduct.
Right. So
How do we get there, I guess is my question.
How do we get to?
And should we get there? I mean, this question of whether Ms. Troughton's killing and Ms. Lewicka's killing are part of the same course of conduct.
I think you would have had to have the jury make that finding as far as that they were in the same course of conduct, and the fact that they
So
were
if they aren't, I'm sorry to interrupt, but if
Sure.
they aren't part of the same course of conduct, how does that affect our analysis of the multiplicity question?
Well, I think as to count 3, if you say the state can't double count the course of conduct victims, that count 3 is first degree murder. Count 2 does not have Isabella LaVisca in it at all. So if there's sufficient course of conduct evidence to support count 2, then that could stand.
As a first-degree murder, rather than a capital?
No, I think
That's
count
what
2
I'm trying
would,
to understand
yes,
about your
I'm
answer.
sorry. Count 2 would, I think, would remain capital because
Right, but you're saying that count 3, we should count as a first degree rather than a capital.
if you say you can only use course of conduct once and you did it in both
Okay.
counts.
Well,
Yeah,
like,
I'm
but
understanding your answer.
maybe I'm not asking my question clearly, but if we can only use course of conduct once, that's the same course of conduct, right? And I guess I'm just struggling with this logical difficulty of that Justice Beyer referenced. We've got clearly 2 counts,
Correct.
and the jury found course of conduct with respect to both of the post-enactment killings. But what is there that connects Ms. Lewicka's killing and Ms. Troughton's killing as part of that group? How do you get from 5 to 6 is an easy way to say it, from the record?
I'm not sure you can, just because of the way it was pled
And then I guess I'll
proved.
just re-ask my question. Does that impact the multiplicity analysis at all? Because if you can't get from 5 to 6, it strikes me that perhaps we don't know whether this is multiplicitous or not.
Well, as to one of the counts, you could say state you used course of conduct on the killing that occurred between August of '99 and June of 2000. But you can't use it as to the other. You can't say it continued as to the one that occurred from February of 2000 to June of 2000. I think.
Okay.
I think it's still 1 count capital murder and 1 first degree.
I'm having a disconnect here.
Okay.
The way you charged it is the 4 murders were part of the course of conduct with one of the pre-enactment murders. Or post-enactment. And the same with the other person. So how can you have all of the murders in one be part of the course of conduct, all the murders in the other be part of the course of conduct, and then the two post-enactment victims not be in the same course of conduct?
Right.
I mean, if the Miss Trouton was in the course of conduct of the same four people that were in the course of conduct of Miss Elwicks, how can they not be in the same course of conduct with each other?
Well, I guess we charged it that way, the same course of conduct with two separate post-enactment victims. My argument is that if the court says you can only have one count of capital murder based on that, because you use the course of conduct twice, then one of the counts would be a first-degree murder, and one would be a capital murder.
Is it, I guess another question is along these lines, is it the same course of conduct for Trouton and Lewicka in terms of the common scheme or course of conduct? Is it the same? You reference Bonner and the Faiths and Stassi in both, but is there a different theory on how the course of conduct evolved for each individual? I didn't see one. I don't think it was argued that way. But is there a different route for each charge to get to the course of conduct, or is it the same?
I think the argument was the same, that they were both lured to the area for these two for BDSM purposes, and that they were both killed with the same blunt object to the head, disposed in a barrel.
So there's really no distinction between the two and how you arrive at the course of conduct or common scheme. They're both the same.
Yes.
Okay.
Just on the facts, they're more similar to one another than they are to the four predicates. And just on the facts, they're found
Yes.
together and more contemporaneous. And there's just
Yes.
lots of similarities between those two. Okay.
Which gets me circling back to why the charging document is drafted the way it is, and I'm not hearing a very good explanation from you. And it's important because I'm struggling with this notion about whether pre-enactment crimes can get lassoed and put under the capital murder statute. And all of that could have been avoided by just taking all the same related crimes and throwing them into one capital murder count, because then you would have had two post-94 killings, and so under any argument that they've made, you'd be okay in terms of application of the capital murder statute. But now we have to wrestle with this argument, and it's not a bad one. And so, I mean, is there any clue as to why you did it this way? And it's not enough to go back and just say, well, there was this explanation. I mean, can you defend today, under any notion, even regardless of what was said before, can you defend on any notion charging each of these victims with under a capital murder scheme that seems to require more than one killing, that maybe need to fall in a post-enactment scenario?
I agree. As we stand here today, that would have been simpler to have charged it that way. We didn't because of, I think, what the state's understanding of the law was back in 2000.
Which was what? That's what I'm not clear on, and I didn't see it in your briefs. I just am struggling with trying to figure out why you did what you did so that I can decide whether I agree or not.
Right. And I know this was discussed at the bind-over hearing, Justice Biles. I just don't remember what the state's explanation was for why we didn't include Trouton and LaVisca's count on capital murder. I don't remember, but I know the state thought there was some sort of problem if it was.
What do you
charged
see
that
as
way.
the unit of prosecution under the A6 and the capital murder statute?
The unit of your this court has said the unit of prosecution is the killing of more than one person is the unit of prosecution, and we saw that in Scott and several other cases.
Would that include the second victim?
I don't think that would include the second victim, because the second victim is not alleged in the first victim's capital murder count, and vice versa. So I don't think it would be the same.
One other question about this, and I can't remember the count number, but it's the Lisa Stasi first-degree murder conviction.
Yes.
Because you included her under your common scheme under the capital murder, under our multiplicity case law, doesn't that conviction have to go away?
If
Assuming we affirm the capital murder.
If you affirm on the course of conduct and that she can be part of the course of conduct, then yes, that count would have to go away. But if you don't, then that count would stand.
If, I didn't understand that. If we don't find course of conduct, and you lose your capital convictions, then that's when it stands? Is that what you're saying?
If you don't find that she was part of the course of conduct.
If we don't, but you did in the conjunctive, all four of the prior victims.
Right.
So if we find that she was not part of the course of conduct, don't you fail on your capital counts?
Well, the capital count just requires a killing of more than one person, so there's still 3 other people.
Even though you charged it in the conjunctive, all you have to do is prove that at least one other person?
Well, it was charged in the conjunctive, but you still have a killing of more than one person if.
I thought we had agreement that you had to prove all 5 on each capital count. No? That was this theory the state elected?
Right, that the jury was charged that, yes.
Yeah,
But-
it was charged that way and the jury was instructed that way, that they had to
Yes.
find all 5.
But
right?
is it still not a killing of more than one person if you say it's only?
So are you making kind of a harmlessness argument?
If, well, as to count 5, the first degree murder, I'm saying that if the court does not find that Lisa Stasi is part of the course of conduct, that count 5 stands, that if.
I understood that
Okay.
point. I was just confused by your response to Justice Johnson, because I thought you had told me that you agreed the state had to prove 5 murders in order to prove the 2 capital counts.
Right, and if we just proved 4 murders,
Then
it's
the
still
Lisa
capital.
Stasi first-degree murder count would stand if she wasn't the one that had an absence of proof.
Right.
Okay, I understand that point, but do you agree with the predicate point, if you will, that in order to prove the 2 capital crimes, you had to prove 5 murders?
Yes, but
Okay, that's all. I just wanted to make sure. I thought we had that understanding, and then I thought I heard you say
well,
something
but
else.
maybe it is a harmlessness because it's still more than one person if she's not included in the capital murder count.
I understand that.
Okay,
But what did the state have to prove on the 2 capital charges?
all 4
5.
course of conduct.
All 5.
5 on
sorry.
each.
Yes, 5 on each.
Okay, thank you.
Okay.
We didn't need to belabor it.
And you can't have an accidental course of conduct, could you? The subsection 6 talks about intentional and premeditated killing of more than one person in 2 or more acts or transactions constituting parts of a common scheme or course of conduct. That would indicate to me that the defendant would have to intend for these 2 or more killings to be part of a course of conduct. And how can you have that premeditated intent if it wasn't even the law yet on the prior killing?
Right.
You understand what I'm saying?
Yes, I think I
Just
understand.
serendipity, I happen to have killed someone, so now I get caught. Well, it says intentional and premeditated killing of the more than one person as part of a course of conduct. So it seems to me that couldn't be an accidentally implied course of conduct, the way it's worded.
No, I don't think it could be an accidental course of conduct, but the as to at least three of the victims, Beverly Bonner and the Faiths, they were killed sometime in 1994. We're not sure when, so those might be the straddle offenses. As to Lisa Stasi, that's in 1985. At the time of that offense, that's still a murder. And then in 1994, you have the capital murder statute being enacted. And if the killing is a continuing offense, and I think from the language stating that you have to have a common scheme or course of conduct, then killing more than one person after that date, the intentional and premeditated killing would constitute your common scheme or course of conduct. And I started with a discussion of the ex post facto type cases because there's not a lot out there as far as straddling offenses. We have and it's not an ex post facto violation where a statute applies to a crime that began prior to but continued after the effective date of the statute. And at page 254 in the blue brief, United States versus Alkins is cited, which dealt with a mail fraud conviction where acts occurred before the statute was enacted, and then there was an event that triggered the application of the statute afterwards. In this case, the last act necessary to trigger application of KSA 21-3439, after July 1 of 94, we have the murder of Suzette Troughton and Isabella LaVisca. We have a course of conduct as far as correspondence with relatives about all the great places all the victims are going. And so we have acts that constitute capital murder after July 1 of 1994.
And that would be a good argument if the statute were worded differently, if it had said killing someone after having previously killed someone or whatever, but it speaks to intentional and premeditated killing of more than one person in 2 or more acts or transactions constituting parts of common scheme and course of conduct. So that's speaking to 2 acts. It's criminalizing the doing of 2 acts. And what you want us to find is that one of those acts could have been done before this statute was passed. And I'm having a hard time reading that language and seeing how you make one of the acts be a pre-enactment act. You understand what I'm trying to say? It doesn't
Yes,
say killing someone after having previously done it, or like possessing after having been convicted of felony. It's not saying that. It says 2 or more acts in the active sense.
Right. I think the intent of this subsection is to apply to serial type killings of more than one person.
How do you get that? How do you get that? We adopted this, our death penalty from Virginia, and it didn't have that language. And from what I can see in the legislative history, no one really knows where it came from, other than opposing counsel seems to think it was imported from the Hard 40. But I don't see any legislative history that tells us this was added because of serial killers. And we just making that up?
I did not look at the minutes of the hearings in the House and Senate on that, Justice Johnson, but I think the fact that it says you have to have killing of more than one person as parts of a common scheme or course of conduct would cover a series of killings. And
Well, does the state have a position as to when these 2 charged capital crimes were committed?
the jury was instructed that on the dates that Isabella LaVisca and Suzette Troughton.
Well, is that the state's position as to when the crimes occurred?
Those were the killings that triggered the capital murder, the killing of more than one person. So
Just make it easy. Before Ms. Troughton was killed, had that charged capital murder count, had it been committed yet?
no.
And so the state's position is when Ms. Troughton was killed, that's when the crime occurred, the capital murder crime that Mr. Robinson was charged with.
Well, Troughton was the second one to disappear.
We could go through the same sort of line of
Okay.
questioning with each capital
Right,
murder charge.
okay.
But
I would say when Isabella LaVisca was killed in August of '99 or thereafter, that would have triggered application of the
okay,
capital murder
and
statute.
that was post statutory enactment.
Yes, it was.
obviously. So do we even have a retroactivity issue here, or is this statute just being applied not retroactively? It's being applied on the date the crime occurred, which is post enactment.
Yes, I think it is post enactment that the killing. If he had killed nobody after July 1 of 1994, it would not have been a capital murder, and we have this continuing course of conduct and a killing in 1999 and one in 2000.
And I guess I'm just asking you to address head on this question that Mr. Robinson raises, which is he's saying you can't apply this statute retroactively. And I'm asking you whether or not, just address that head on. Is this statute being applied retroactively or not?
I don't think it's being applied retroactively because it's triggered by the post July 1, 94 killings of Isabella LaVisca and Suzette Troughton.
But what you're saying is that the two or more acts or transactions do not have to occur after the enactment. Because this doesn't say you just kill one person with a prior. I said that before. It says that as killing of more than one person in two or more acts or transactions. And what you're really saying is those transactions can span on each side of when this provision came into being.
I think that's what I'm really saying, that it's a straddle offense is how the ex post facto cases refer to it. He's on notice not to kill people after July 1 of 94 or a person that triggers the application of the statute under the course of conduct, and that it applies, and that we're not punishing him for killing Suzette Troughton or LaVisca before July 1 of 94. It's based on what he did after that is what triggered the application of the statute.
Before you run out of time, could I ask you about the taking of the Bible or the use of the Bible by one of the jurors?
Sure.
I'm having trouble. Apparently there is some case law that indicates that a juror, single juror, can consult and use the Bible to help make a decision, but can't actually read the verses to the other jurors. And I'm trying to determine why that isn't using something else besides the law as instructed. In other words, if I take the Bible and say, I know what Judge Anderson has instructed me, but I'm going to look at the Old Testament and I'm going to decide this case based on my reading of the Bible. If that's the case, why couldn't I bring my thesaurus in and look up mercy and talk about it, or bring in Oklahoma case law and say, well, I'm going to decide it on that basis. I'm having a little trouble, even if one juror uses that resource to reach its decision, why that isn't a violation of our prohibition against using anything other than the law as instructed. Okay?
As discussed in the brief, the cases seem to say that it obviously cannot be in the courtroom, but they're citing the Bible could be allowed
From memory.
from memory.
I have a question here, a fact question really,
Okay.
about what this juror did though. Didn't it was a he? I think it was a he.
Yes.
Didn't he characterize what he had done as research on mercy, as opposed to some private devotional practice?
As I recall, and all the jurors were interviewed after this happened, that he had.
I'm not talking about what anybody else said though.
Right,
I'm just
no,
talking
I
about
know.
what this one said.
Right. that he had come to his decision, but wanted to check the Bible to see if that would change anything.
Okay, so he employed it in his decision. I mean, he'd come to a decision, but he was checking to make sure it was consistent with what he saw there. I'm just trying to get at the difference between a private devotional practice,
Right.
which I think the cases, at least some cases indicate is fine, as opposed to doing research on another source of the law, as my colleague has suggested, or another source on what should control the decision. And my memory of the record here is that even the juror involved characterized what he was doing as research rather than a private devotional practice. And so even if none of the others were influenced by what he saw or did, don't we still have a potential problem?
Yes, I think there's a potential problem. The juror's comments, and it's at page 20 of the transcript, Judge Anderson asks, so the Bible did not result in being of assistance in reaching your individual determination in the case. Juror 147, no sir, it did not. Then he says it reinforced my decision. As Judge Anderson said at the motion for new trial, it was unfortunate that it was in the jury room. The jury went in at 9:15 to start to deliberate. That, I think it was a Saturday morning. The administrative assistant noticed the Bible in the courtroom, and by 9:20, the that juror was taken out, and deliberation stopped. And about the next 5 hours was Judge Anderson and one of the attorneys from each side asking the jurors if the impact of the Bible was discussed in their deliberations.
Can I understand that the state of deliberations were that before this juror was called into chambers, they had reached a unanimous verdict, but had not written it down yet? Is that where they had voted, reached unanimity, and then after that there was some discussion, oh, by the way, I did, is that kind of the sequence, is that correct?
That is correct, and this was during a course of decompression where the one juror made the statement that I'm not sure how many of the others heard. And then the night before, the jurors had also reached a tentative verdict and wanted to sleep on it. Then they come back the next morning, and that's when this happened.
But the verdict form had not been signed until after all this discussion with the judge, is that right?
The judge instructed the jury that you shall not consider the use of the Bible in your deliberations, sent them back to deliberate, and then they came back with their verdict.
Thank you.
And I think Judge Anderson discussed at the motion for new trial that they did everything they could as far as avoiding things like this. The jury was sequestered and at a hotel, and there was a Bible in one of the hotel rooms, which is how it even came up. But he was convinced that his ruling did not deprive the defendant of a fair trial in that case.
On this question of potential juror misconduct for the use of a Bible, is there any tension or perhaps inconsistency between the positions the state has taken with respect to jury nullification on the one hand and the use of the Bible on the other? In other words, the state's taken the position that it's not error to instruct the jury that they shall follow the law, essentially. That's on the one hand, but on the other hand, you've taken the position that it's okay, in some circumstances at least, for one juror to individually consult the Bible. It strikes me there's at least a potential inconsistency between those two positions.
As far as the supplemental brief, I think you shall impose a sentence of death, follows the law. The incident with the juror was wrong, was misconduct, was harmless, is our argument, and we're not sanctioning.
He's asking a deeper question. He's asking about a philosophical inconsistency between taking the position that nullification is improper and that the jury should not be allowed that possibility. At the same time, you say it's okay for one juror to consult the Bible to help to govern his vote or reinforce his vote. Do I
Thank you.
misstate?
No, that's, I appreciate the
And
restatement.
I should have caught that the first time, I guess.
I'm just
that you asked
asking the same question. I think that's a very interesting, but a deeper question than what you addressed on the shall and should.
I don't know what, I mean, the juror, it was wrong to do that. I don't know if it.
You're just taking a hardline anti-nullification view, which is the jury really doesn't have a so-called right to nullification. They do have to stick to the law only, and that any consultation of anything outside what the judge instructs is misconduct. It just might be harmless. Am I summarizing your position correctly?
Yes, but I distinguish the Smith-Parker case because that's a guilt phase instruction.
I understand the distinctions you're trying to draw, and so on. I really was trying to drive at what Justice Breyer describes as sort of the deeper philosophical question about what are we expecting of jurors, really? What do we expect them to do, and what do we allow them to do?
Right. And as much as you instruct them to don't discuss the case, consult outside sources, jurors sometimes stray. And
in fact, this court has been at least hesitant in Smith-Parker in some circumstances to tread too heavily on a juror's ability to render whatever verdict that juror deems right for whatever reason.
yes, I think so. And I didn't know if the court had any questions on any of the other issues, search and seizure or anything like that. I'd be glad to address those.
Does that conclude your presentation, counsel?
Yes, I would like to make a concluding comment, but yes.
Any more questions? All right, please continue.
Thank you. I would just hearken back to the motion for new trial hearing. The defense, who claimed they didn't have time to prepare for the case, filed a motion for new trial that made 103 claims, a lot of which we see in the brief. And Judge Anderson, the governor of the trial, considered all of these claims and arguments and said, I have no doubt this was a fair trial and the defendants received such. And there is no, in this court's humble opinion, error that would justify a new trial. And for those reasons and the reasons argued in the brief, the state would request that the convictions and sentence be affirmed. Thank you.
Thank you. You reserve 10 minutes for rebuttal.
Counsel, if I could just jump in right before you even get
Please
started.
do.
Just because it's an easy segue, I really want to ask you the same question I asked Mr. Obermeyer, and that is, I see the same potential inconsistency, at least in the positions the defense has taken with regard to jury nullification and the use of the Bible. Help me understand how you can take the position that a jury has a right to nullify, to render whatever verdict they deem best for whatever reason. How do you reconcile that with your position that the jurors are not permitted, and in fact it's reversible misconduct if a juror consults the Bible?
First, the jurors' exercise of nullification has traditionally been defined by this court and others as being the right to find a defendant not guilty even in the face of evidence of guilt. Nullification isn't ordinarily used to talk about what jurors may do in the state's favor. And in fact, there are certain things that it would be a due process violation for jurors, decisions for jurors to make or actions for jurors to take, not following the law in the state's favor, whereas the state doesn't have a due process right to a not guilty or a no doubt.
So nullification works in one direction only.
It's normally spoken about as working in one direction only.
And I appreciate that. I think that's right in terms of the way it's talked about. And that just leads to my last follow-up question, which is, wasn't the jurors, as a matter of fact, in this case, wasn't the jurors' consultation of the Bible in that one direction that you're talking about it being allowed? In other words, a consultation of another source to search for a factor that might favor Mr. Robinson.
I understand.
Do
What
I,
happened- oh,
excuse me,
pardon.
do I remember correctly that he had said that he wanted, as my colleague said, wanted to research mercy, and that the Bible had instructed him that mercy requires being remorseful? Is that my recollection? And
About
if
his,
so,
his
that-
interpretation of the Bible.
And
Yes.
if so, that would be restrictive of using mercy,
Sure.
which was instructed as being a mitigator.
Correct. So I think that what Justice Stiegel is maybe saying is that the juror set out to maybe help the defendant by looking for a reason to exercise mercy. But what he found was a reason he viewed as not to exercise mercy. And I would agree with Justice Breyer. This juror did say he was researching in the Bible, and the fact that he bookmarked it and took it back into the courthouse within the next day also suggests that he was not simply consulting it for comfort or sustenance, but rather to aid in his deliberations. And the state argues that this misconduct was not harmful, but I didn't hear a reason why it wasn't. I didn't hear an analysis of harm from the state. And we've set out some discussion of how the court might analyze harm from this kind of misconduct, including the fact that the juror was researching an issue that was crucial to sentencing, mercy, that Bibles are considered authoritative by typical Kansans, that the juror initiated the research. It wasn't foisted upon him by somebody walking up and talking to him about the case. He shared it with other jurors. His research occurred before the final verdict, and it was the type of research that would influence a typical Kansas juror. I think I'm repeating myself. And it conflicted with the court's instructions, which did not say mercy requires repentance. And the judge, although the judge gave curative instructions, they were sort of contradictory, because at the beginning, I know the judge was trying to put the jurors at ease, but the judge said to each and every juror, nobody has done anything wrong here. So the instruction basically said, from here on out, don't consult the Bible. Finally, the Bible research compounded the prosecutor's misconduct when the prosecutor brought up that question of lack of remorse because the prosecutor, never saw the defendant cry. So those are all things that suggest there was harm from this juror's misconduct. To get to, I believe, one of the questions about the retroactivity, whether this was an application of the statute retroactively, the answer is yes, because Suzette Troughton's death is not capital without those essential elements of the pre-statute killings. Isabella Levica's killing is not capital without those pre-statute killings. Those are essential elements. They aren't simply part of what happened in a course of conduct. They are essential elements without which these crimes as charged without which the charges would not have been capital. The state suggests that on the multiplicity problem, maybe one remedy is to leave one of the capital charges in place and then simply remand the second one for resentencing for first-degree murder. But I don't know that there's any authority for that kind of solution to a multiplicity problem. It certainly wasn't. I don't know whether that would have been possible in the Carr case, for instance, or in Harris, but that's the solution if there is insufficient evidence as to an element like the capital element here. For instance, when this court had the 1,000 feet of a school cases and the 1,000 feet element was missing, then you can remand. But I don't know of any other category of cases in which that's an appropriate result. And it also doesn't address the problem of the piling on of capital charges and how that might prejudice the jury against the defendant. Not only did he kill 6 people, but these were twice capital charges instead of just once. And I realize that's a minor consideration. The continuance claim, I wanted to point out at the outset of the sentencing phase, I think the court was wanting to know a little bit more about why the defense did not carry through with this evaluation that the defense had requested. At the outset of the sentencing phase, defense counsel renewed the request for the continuance, and explained, look, we have an abnormal MRI from the early 90s showing abnormalities in the brain of the defendant. We have a psychiatrist who advised the defense team this was potentially quite significant. However, we can't just get a new brain scan and put that on. If you just tell the jurors this defendant is mentally ill, that might be seen as just as much an aggravating factor as a mitigating factor. The defense lawyers in this case, who were handpicked because of their expertise in litigating capital cases, and were in fact the only people in the courtroom who had previously litigated a capital case, were telling the judge in good faith, and I don't think the court found that they hadn't acted in good faith, that we can't put together a real case of mitigation in the time that we have. And when the judge denied the continuance again, the judge again noted that you're not getting this continuance because in 2001, Mr. Robinson chose to discharge the capital defense team and retain Bob Thomas. And so to bring this argument back around to the Haney case, I understand the differences, of course, between Haney and this case, but it seemed like one of the reasons in Haney that this court reversed was because the court didn't like the reason the judge gave for denying the continuance, because there was a different kind of reason. The judge said, well, the defendant can just testify. Here, the judge's reason was equally troublesome because the judge was wanting to lay the blame on Mr. Robinson for hiring private counsel, which was his right to do. I wanted to make just a couple of little factual corrections with respect to the prosecutorial misconduct. The state argued that there was evidence to support the argument that Debbie Faith watched her mother get killed, and the state argued that there was evidence that they were always together, and that was the phrase the state used, always together. There's no evidence that they were always together. Any evidence of their life before they came to Kansas was that they had a fairly ordinary life. Sheila Faith, Debbie Faith, the daughter, went to school. Debbie Faith, the daughter, had her own friends. There's no reason to assume that because she was disabled and in a wheelchair that she was basically an appendage of her mother. And the state is speaking out of both sides of its mouth here, really, because it also wants you to believe that Sheila Faith went to Missouri to meet Mr. Robinson and have sex with him. Is the state saying that Debbie Faith was with her mother when she went to have sex with Mr. Robinson? I don't think the state is saying that. They don't have evidence to support that argument. I'm going to pause and catch my breath and ask if there are any other questions of the court.
Any more questions?
I just on the jury instruction on the aggravating circumstance that the state chose to use was basically a killing of more than one person.
Yes.
And you said that came from your theory is that came from the hard 40 statute. There's really, as an aggravator, explain that to me.
Oh, yes. The hard 40 scheme was adopted before the death penalty scheme.
Right.
And when the death penalty scheme was adopted later, the legislature simply took that same group of aggravating factors, and actually what they did was they renamed that statute the death penalty aggravators, and then they took another copy of the same factors and plopped them in a new statute.
What did the hard 40 scheme didn't have as an aggravating factor the death of more than one person, did it?
It did.
Okay.
It had
It was risk of great bodily harm to more than one person.
They're linked, and they were linked in the hard 40 statute. It was knowingly or purposely killed or created a great risk of death to more than one person.
Okay.
So yes,
that clarifies it for me.
Okay,
Thank you.
Great, sure.
Any more questions? Would like 30 seconds to conclude.
Thank you very much, Your Honor. I just want to say I appreciate the court's patience with this extremely complex case, and again, we just ask that the convictions be reversed and the death sentence is vacated. Thank you.
Thank you. We thank all counsel for your arguments this morning, and the court is not prepared to rule at this time, but we will take this matter under advisement. Court is now adjourned.